Okay, so without further ado, I would like to welcome Dr. Kimbrough Stevens. He is with Elder Law. He does elder law and special needs law in Little Rock, Arkansas, and is an expert in this area and has been gracious enough to give us an hour of his time today um, to share important information. So I will let you take it away.
Okay. My name's Kimbrough Stevens. It's a pleasure to speak to everyone today. Um, I just want to make sure, Bonnie, that the slideshow is showing. Is it up? Okay.
It is showing, it's showing your notes and
Okay.
the next slide as well. So I don't,
Okay. Well, let me just redo this then. This will be easier. Um, oh, it's going to do that anyway. All right. Well, that's fine. We'll get started and y'all can follow along with me. So again, I'm Kimbrough Stevens. I'm an elder law attorney in Little Rock. Um, I've been practicing since 1988. I was in healthcare for many years, mental health care, ran hospitals and so forth. The last 15 years, I've been doing elder law and special needs planning. So uh, So here we go. And again, I'll be happy to answer questions at the end of the slide. So let's talk about the basics of special needs planning today. Um, we basically, I'm going to discuss a little bit of overview, and we'll talk about working with families, what kind of benefits we're talking about for special needs clients, and the two basic primary types of trust that we use. And then I'm going to talk about some common mistakes and concerns with special needs planning. Also, I'm going to zip through these slides fairly quickly because I know we have a limited time. And so these slides will be available later. And of course, if anybody ever needs to call my office and follow up for any questions, I'd be happy to speak to anyone, and we'll provide my email to folks if they need to follow up. What are the benefits of planning? Well, we want to provide financial security for those that need assistance in getting along in life and their living situation. Uh, we want to leverage means tested public benefits. I'm going to talk about SSI in a minute, which is the one that we plan for. We want to make sure that we have a proper team in place or trustee, that there's appropriate housing, planning for the long term for a disabled person. We need to provide, advocacy, caregiving, perhaps. We have to coordinate with extended family. And of course, the main issue is we want to protect the beneficiary from predators and preserve assets during their lifetime. And so, do all persons with disabilities require special planning? Well, if you're on SSI or you're receiving Medicaid as a means tested benefit, then yes. Otherwise, if you are over 65 and on Medicare, or if you're on Social Security disability insurance, that is not a means tested benefit. So it's not based on income or assets. And so that's really not an issue that we address with special needs planning. So basically, we're working with people with disabilities that have not achieved SSDI status because they worked in the community for 10 years or 40 quarters. We're primarily looking for people that either were disabled at birth or had acquired a disability because they couldn't work and didn't work, and they fall into supplemental security income, which is SSI. Some of the issues that we deal with disabilities is a lot of times we don't include the disabled person in the planning. And that may be because the child's young and we're doing other things, but it's always important to keep the individual in mind. Capacity issues are important that when we're dealing with disabled folks, sometimes if they have lack of capacity, then, that could be an issue, but not always, of course. But we rely on others, and it can be difficult at times. So working with a disabled client can be challenging for a lot of folks, particularly in the classroom for teachers and so forth. We also need to work with the family. That is the main issue with planning for special needs kids. Is it's all about the family support system. And you know, it's a good idea usually to research the condition so you can better communicate with family about what issues may arise. You always want to make sure that whoever's involved in setting up a plan, that the decision maker is in the room. I can't tell you how many times I could come up with a plan, but the person that's really pulling the strings in the family is not in the room. And you'd be surprised at how things can get distorted from the time that you meet with a family and the decision maker hears something, and they may come in and sabotage your plan. They don't understand it. They're not in the room. So everyone needs to buy in to the plan, and whoever the decision maker is someone that needs to be in the room. I always ask my clients when I'm meeting with them, who else it needs to be here, who's going to be making decisions. And if they're not in the room, then that lets me know up front that, you know, we're going to have more discussions. So what are the public benefits that we're mainly looking for? Okay, we have needs-based public benefits. These are the benefits we're talking about. That's SSI, that's Medicaid. It does not include entitlement to public benefits like Social Security, disability, insurance, or Medicare. And of course, Section 8 veterans benefits are things that Section 8 is housing, veteran is for veterans that served in wartime or not. And again, we're not really discussing benefits for those groups. We're only talking about needs-based public benefits. And so I'm going to go through kind of what SSI is. SSI provides a monthly cash grant of $943 to an individual. Now, when we say an individual, we're saying someone that's disabled, blind, or the aged, of course. Now, for those geeks in the room, if you want to go study the Code of Federal Regulations and so forth, they're listed here. And I'd say have at it and study these if you'd like. So what are the requirements for SSI? You must be a citizen or lawful resident. You can't be an illegal alien. They're not going to get any benefits. We'll just put that to rest now. But you can't be a felon. You must reside in the United States, and you must apply for benefits. It's not automatic. You have to go through a process of eligibility determination through the Social Security Administration. What are the eligibility requirements? Well, first of all, you have to be considered disabled medically. And we'll talk more about that briefly in a second. But the primary thing is, I guess we could say you must be poor. Well, what that means is that the individual themselves are limited in what they can have in actual resources. There are certain resources that are exempt, so you can have those apart from the value, but there's also an income test. If you receive an income, it gets deducted from SSI. The definition here again of disability is that you can't be substantially gainfully employed, or substantial gainful activity is the buzzword for Social Security, for a period of at least 12 months. So typically, if you've got a disabled child from birth, then they're never going to work. When they turn 18, then they're eligible for SSI at that time. Or you could become disabled after you're 18 because you can't be gainfully employed due to a medical disability. And once it's determined that it's going to continue for a period of 12 months or longer, then you can qualify for SSI if you have not paid enough money into Social Security to qualify for disability insurance. So what is the resource test? Well, accountable resource limit for SSI is $2,000 for an individual. That's not long at all. It wouldn't take very long to for someone to have that kind of money. So the issue here is, so how do we care for someone that can't have resources? Well, okay, that's what the purpose of special needs planning is for, is to help to care for this individual because they're not entitled to have very much. And yet at the same time, you can't live on $943 a month typically. So that's the purpose of do special needs planning, to set up ways to help that individual over the course of their lifetime. And this $2,000 is measured on a month-to-month basis. So at any time that an individual has more than $2,000, technically they would be disqualified the following month until their resource limit came down. Now, let's talk about what I said a second ago about there are some exempt assets. You can own a home, and that's fine. Now, under Medicaid, the value of the home that you can own is in the $700,000 range. So we're talking about a substantial amount of property that you can own in your name as a primary residence. You can also own an automobile, and that can be of any value. And of course, there's other things such as household items, musical instruments, burial insurance, life insurance policies with a cash value, though, of only $1,500 or less. Of course, term policies are excluded. So a person with a disability can own and have items in personal things. But again, these are the limits that are considered non-countable assets toward that 2,000. So, and then when we think of Social Security income, you know, these are the types of things that will affect your SSI income, unearned income and earned income. Now, just because you're on SSI doesn't mean that you can't work. I mean, some people on SSI do some work. Maybe it's, you know, to help someone from time to time. We're trying to help them to be as independent as possible, and for the you know, self-esteem of the person and so forth. It's good for them to be involved in things. However, when you do receive money, either through income or through gifts or other things, and that's considered unearned, it will affect the disability payment from the government. The government wants to be the payer of last resort. If there are other resources available there, you know, and you get enough of it, you're going to be denied SSI income payments. So again, these are things to keep in mind. So you don't give cash to an SSI recipient. That will basically, after the first $20, that would be it would be subtracted from their SSI benefit. Okay. There are other types of SSI income that would affect, and the one that I talk about sometimes is called in-kind support and maintenance. Now, what that means is if someone is paying your rent for an SSI recipient, that will reduce their SSI benefit. It used to be that if we paid or gave food as well, that was also an in-kind support that would diminish the SSI monthly payment. However, as of September the 30th, the law changed, and now we can provide food and food subsidies to SSI recipients without affecting the $943 that they receive. And we'll talk more about that here in a little while. But so we have exempt income, unearned income. So $20. So if they can make up to $20, that's exempt. Big whoopee, right? But anything over that, if you earn more than $65, then it's deducted dollar for dollar from Social Security. And that's, you know, so the rule of thumb here is we have to manage the cash that any SSI recipient receives, and there are ways to do that. Again, unearned income again can affect Social Security, SSI that is. And now this is the in-kind support and maintenance that if you provide a disabled person, and this all has to do with housing. Every one of these are essential for housing. If you pay rent or mortgage, pay property taxes, anything of that nature, water, sewer, electricity, gas, and garbage removal. It does not include telephones. It does not include cable. It does not include the internet. It doesn't include a lot of things that third parties can pay for that will not affect their SSI payment. So the issue here is if you provide SSI in-kind support, what that means is SSI now is supposed to be for these items that are on this screen right here. And if you are a third party, someone else is providing that for them, then SSI is going to say, well, we're going to reduce that benefit because someone else is providing those services. So the $943 should be exclusively used for these items. Some people think, well, if I want to get below the 2,000 limit, I'll just give my money away and then voila, I'll be eligible. But there is a penalty for making gifts. Again, that's why pre-planning is important. And it could disqualify someone for up to 3 years if they made substantial gifts. There's also reporting requirements so that if someone is on SSI, every year you have to answer questions from SSI, typically, not always every year, but often enough that if you have a change in your circumstance, you're required to tell Social Security that. And if they come along later and do an audit and find that you were ineligible for a period of time, they will basically go back and find all the money that you received during your period of ineligibility, and they'll deduct it from all future eligible payments going forward. So it's very important that you manage your benefit arrangement at all times so that you don't affect future benefits. So let's talk about how we would handle planning for someone. And the primary vehicle that we use is something called a special needs trust. And why do we use a special needs trust? Well, a special needs trust is, there are two types, a first party and a third party. I'll talk more about in a minute. But the idea behind the trust, generally speaking, is it acts as a firewall between the disabled person and the money that is available for their benefit in a number of ways without disqualifying the means test of owning $2,000 or having excess income. So for instance, a parent could set aside money for a child without losing government benefits, whether it's SSI or Medicaid, by placing that money in a trust for the child. The money in the trust can be spent on all the extras in life, including food, just not housing. But one thing that we have to address is it can only be done at the discretion of the trustee. The trustee holds the key to the money with the absolute discretion to disperse it or not. We basically call the special needs trust a discretionary trust. If it wasn't discretionary and it said that it's for the support of the individual, then that would by definition count as a resource and could disqualify. Because if you create a support trust, it's intended to support the individual. And again, Social Security wants to be the payer of last resort. So now the person's disqualified. If it has to be used for the health, education, maintenance, and support of a person, and we call that the HIN standard, that would disqualify the person for benefit. So there is no HIN standard in a discretionary trust. It's basically at the sole discretion of the trustee. And then the trustee needs to be responsible for making sure they don't spend it in ways or give cash to the individual so it disqualifies them. So that's why it's important to choose your trustees carefully. So what does a trustee do? Well, they basically have two jobs. Their job is to manage the funds or the money or the real estate or whatever is there and distribute it based on what the trust says at the discretion, of course, of the trustee. Turn that off. So Selecting a trustee is very important. It can be a person. It can be a corporate trustee. You can have a combination of the both. But who cannot be a trustee is the person with disability. So a disabled individual who's receiving SSI cannot be their own discretionary trustee. If they did, the trust would count as a resource, and of course it would disqualify them. Now, this is what I mentioned a minute ago. There are basically two types of special needs trust. One is third party. What that means is someone other than the disabled person is the grantor of a trust and puts money in a trust for the benefit of the disabled person. Hit my do not disturb here. There we go. A first party trust is basically what we call self-settled. In other words, the disabled person themselves create the trust with money they have, either through inheritance or whatever means. And so it's the person with the disability. We call that a first party special needs trust, separate from the third party. We have greater flexibility with a third party trust than we do with a first party trust. So we'll go through what a third party trust can do first. Generally, it's created by a family member, and sometimes it's created after death through a will or some other mechanism, or it can be created during the lifetime of the grantor. But the most important thing about a third party trust, unlike a first party trust, is once the disabled person passes away or for any other reason is no longer receiving benefits, you do not have to pay the government back for the benefit. Unlike a first party trust, which I'll talk more about here in a few minutes, but the government is still involved in the first party trust and could be is the primary beneficiary upon the death of the disabled person. The state is not a primary beneficiary of a third party trust, or at least we would say that it's not a requirement. A first party trust, obviously, and I just mentioned this a second ago, it occurs when the person with the disability creates the trust. Well, why would we ever have a situation like that? And this happens a lot. Someone dies, a relative, they leave money to a person who's on SSI or Medicaid, and they're looking at now being disqualified. But the government and the law says that if that person will put that in a trust for their sole benefit, and it's managed by a third party as trustee, then it will not be counted as a transfer against the 3-year penalty rule. And it allows you to put an unlimited amount of money in a trust for the benefit of the disabled person by the disabled person and still qualify for SSI. However, at the end of that person's life, or if they cease, receiving government benefits, then the state, in this case would be Arkansas, would be the first beneficiary of the principal that's remaining at the death of the disabled person. Now, so that's the trade-off. The government says, we'll let you take this money without being disabled, put it aside, but you're going to have to pay us later on the back end if there's anything left in it. And so that's the trade-off for the privilege of being able to give the money into a trust and keep your benefit. The third party special needs trust does have some requirements, and these are pretty self-explanatory, but you got to have a trustee, you got to have a beneficiary, and the trustee, this is the key, has to have discretion to withhold distributions. These are just more definitions for third parties, and I won't go into that. But there is an additional requirement for a third party trust, and that is that the beneficiary cannot revoke the trust. If the beneficiary could revoke the trust, then it would be counted as a resource. And the beneficiary cannot direct the use of the trust assets. So again, it's at the exclusive discretion of the trustee. The other thing I mentioned, and this is a rehash a little bit, is that there's no payback provision to the state. However, this is another key distinction between third party and first party. In a first party trust, it has to be irrevocable by the disabled person when they create it. And they put that money in there. They cannot revoke the trust. Like I said a second ago in the previous slide, it says that the beneficiary is unable to revoke it. So in that case, he can't revoke the third party and he can't revoke the first party either. But the grantor can revoke a third party. So the grantor, remember, is a third party. It's a parent, it's a relative, it's anyone other than the disabled person. That person can set up a revocable third party special needs trust, and they can change the terms if they need to and so forth. But once that grantor passes away, then typically at that time, it does become irrevocable. First party special needs trust is sometimes referred to as a D4A trust. That's a statute in the federal code. And so sometimes if you hear D4A, what we're talking about is first party special needs trust. And again, what makes it a first party trust is we also sometimes call that self-settled. What that means is the disabled person settled the trust. What that means, it was their money that was put in there. What kinds of events happen when we have first party SNTs? Well, here's a good example, a personal injury award. A lot of times if someone becomes disabled because they're in a car wreck, you know, they weren't considered early in life as a person that might you know, be disabled. And so now they're the beneficiary of a award. Well, they can't just give the award away to a third party at that point. That would violate the 3-year look back rule. So the only other way to handle that is to put it in a self-settled trust. But then again, you have the requirement to pay the state back one day. So a lot of times, those are issues that come up when money is found that comes to a disabled person after they're on SSI and they're trying to plan to keep their benefits. The government allows the disabled person to settle a trust as long as it meets the requirements that it pay the state back once they pass. These are other requirements for SNTs. I'll leave it for y'all's review. But again, the issue here is these are self-settled primarily. And this is the last benefit. It really right here, whoops. That last tidbit there, upon the death of the beneficiary, the trust must repay Medicaid for all benefits received by the beneficiary during his or her lifetime to the extent that funds remained in the trust at the beneficiary's death. What are the good reasons why to have a self-settled trust? Well, you have control over the money and you can still invest the money and it doesn't count against the disabled person's resources. Again, it's a good way to put real estate and, you know, it's just good for maintaining benefits. One of the other things is some of the issues about a self-settled trust is if you're over the age of 65, you cannot use a self-settled trust. So if you're a disabled person on SSI into your senior years, typically SSI at that time quits being resource-based. I forget the exact period of that time, but most folks, once it's established prior to age 65, it can continue indefinitely. Of course, you know, what if you have a trustee that's not acting appropriately? That could be a difficult situation, but there are ways to guard against that, which I'll get into. So let's look at some common mistakes. And we're nearing toward the end here. I will try to wrap this up in the next 10 minutes and then we can take questions. But one thing is to do nothing. And we'll talk more about that here in a minute. We need to have good distribution standards. What if someone's not managing the trust properly, not thinking long-term with a financial plan? It has to be for the sole benefit, typically of a disabled person. if it's a self-settled trust for sure. Distributing cash to an SSI recipient is taboo. Also, sometimes trustees think they shouldn't spend money in certain ways to enhance the quality of life for a beneficiary, but that's what it's for. The primary thing they should avoid is housing. And it used to be that we couldn't provide food or food subsidies, but that has been changed. And one of the other issues is not maintaining good records. And we'll discuss more about why that's important. So what if I don't do anything? Well, chances are this child is going to inherit money one day, and it's going to force them into a first party trust that's going to pay back the state one day. If you had done some pre-planning, instead of giving the inheritance outright to the disabled person, the person who passes away can establish a third party trust at that time for it to go into a trust for the benefit of the recipient. And then upon the death of the recipient, if there's any funds remaining, can be distributed to other family members and not the state. So again, if you don't do anything, you have a disabled person in the family that may inherit, don't disinherit the child. A lot of people will do that. You can create a special needs or supplemental needs trust, third party, for that individual, and it will protect that person's benefits as well as provide a legacy to other people in the family. Again, we were talking about a core distribution standard a minute ago. So writing the special needs trust is very important. You need to make sure that someone who writes these trusts are familiar with the best way to set it. But you don't want to be too narrow. If you're too broad, then it could count as a resource. So let's be careful. Poor management of the S&T is another issue. One of the ways to get around that is by using a corporate fiduciary, like a trust department of a bank. There are several trustees that are very familiar with the SSI guidelines and how they can use the money. And most of the time, they come with a minimum amount of money, but most corporate trustees usually charge to manage the funds and to manage the day-to-day operations about 1% of the value of the estate, with a minimum, typically $2,500 or so. Most trust firms will assess that. Another way is you could have a trust advisory committee. You can structure these trusts any way. You can provide a trust protector. That's something else that can come in and remove a trustee if they're not doing a good job. So you do have some recourse to handle a poor management of a trust. But again, all that needs to be included in the front end of drafting the trust. Another deal is not preparing a financial plan. Well, that doesn't have anything to do technically with the structure of a trust, but it has everything to do with, the lifetime of the beneficiary. So it's always a good idea to engage financial planning. So you'll have a lawyer on your team. You'll have a CPA on your team to handle any tax issues. And hopefully you'll have a certified financial planner or someone working with you to help grow those assets in the trust so that the beneficiary does not outlive their money in the trust. Failing to set up a process for distribution. Again, if you have a corporate trustee, typically there's procedures involved, how you email and so forth and keep up with things. If you have a family member, it's more informal and it's fine, but just make sure that whatever mechanisms need to be in place so that the beneficiary doesn't have to wait a long time to receive the funds that they need for various things. Complying with the sole benefit rule. I mean, again, for a first party supplemental needs trust, it has to be for the sole benefit of the individual. A third party, you could theoretically have it for the benefit of other people at the same time, because it wasn't the first party's, or it wasn't the disabled person's money. If it's not the disabled person's money, the sole benefit rule is very flexible. It can be for more than one person, for instance. But whatever's given to the benefit of the disabled person has to be at the discretion of the trustee. Now, if you have the first party trust, what is sole benefit? So that's one of the issues. Well, what if you pay it to a third party who has provided goods or services to the trust beneficiary. Well, they will consider that still sole benefit because the beneficiary received the benefit from a third party that the trust then in turn paid. Again, travel expenses from a party that has to come and do some services for the beneficiary. Again, that satisfies the sole benefit because ultimately the benefit is for the beneficiary. So that doesn't mean that money has to go to the beneficiary. You can pay third parties, but you have to make sure that you're paying a third party that's doing something for the benefit of the disabled person. This is always a no-no, distributing cash to a beneficiary. We have started using something called a TrueLink card. TrueLink card is like a prepaid card that allows the beneficiary to access services, but it can't be used, say, for instance, to pay the utility bill. So rather than remember, you can't give cash to the beneficiary, but they can have a debit card or a prepaid card that's as good as cash, and you can take it to the grocery store to buy groceries. You can take it and buy clothes. You can put gas in your car. You can do all kinds of things with it, but that card will not allow you to go to an ATM and pull out cash. So it protects the individual from violating the terms of their SSI eligibility, but it provides the convenience and access to funds for the benefit of the beneficiary. And you can limit the amount of money the TrueLink card can be used for. And so that's one way to sort of pass out the money to the individual a month on a budget that they can use their card. So that's the way you handle it, but you do not give them cash. Again, some of the problems is sometimes trustees don't understand that, you might be able to pay for shelter. You just need to know that if you are paying for shelter, it doesn't mean that in certain situations, it would reduce the SSI benefit, but then you have a decision to make. It doesn't eliminate it altogether, but up to a third of the benefit could be lost if you're supporting someone in shelter. But the decision making for the trustee there is the person still better off? And so as long as they're better off, you can make distributions for shelter. Otherwise, everything else is pretty much open season. Now the thing about records. So the issue about the records is you must keep records, because anytime you're on SSI, Social Security is allowed to go back and audit from the very beginning. Now, if they've gone back and audited 10 years, they're not going to go back and re-audit that same 10-year. But for whatever period of time they haven't audited, they can audit as much as they want. And if they find where you were ineligible during an audit period, then you're going to lose benefits going forward on a dollar for dollar basis that you received. So again, the first party SNT has a payback provision. Now, one of the things that you say, well, can I pay for funeral expenses after the person is dead, or pay off the debts? No. You can prepay the funeral out of this special needs trust, but you can't do it after they pass. So some of those things the Medicaid agency has to be paid back first. If they're paid back in full, then you can use it to pay funeral and other expenses. But you can pay administration trust and sometimes taxes prior to paying the state agencies. And that's kind of on a state by state basis. Well, I think that wraps me up. That was about 40 minutes. I'm happy to take questions. I know this was fast and furious, but I'd be happy to answer questions at this time.
Yeah, so if anybody has a question, feel free to just unmute and ask that. And I know I have a couple, but I was gonna wait. I'll just go ahead and ask. When you talked about, keeping good records, and if they go back and audit, and they find out that you were not eligible during a period of time, then you lose those benefits forward. Is that just no matter if you became eligible again, they're still gonna deduct that? Did I
Well, what's
understand
happened is they're probably still disabled as far as medically. So it's not as if that they have to reapply per se, but it kind of depends on the length of time that they're off. So if it's less than a year, they typically don't have to reapply. If it's longer than that, they still want to make you maybe reapply because you may have gotten better in the meantime. But typically speaking, it would be a simpler process. They've already got a file on you and so forth. But you may have to contact them and say, my benefits need to restart. I mean, they're going to tell you how long you're going to be without benefits. And then as you get closer to that day, that's when you need to start making sure that that benefit gets restarted at the appropriate time, and it may require some additional documentation at that time. Because for one thing, they're going to want to know what your resources are again to make sure you're still under. So they get to resource test you again at the end of the period of not ineligibility, but you're under a penalty for not being eligible.
Right.
So they get to look again and say, okay, let's make sure you're still eligible at this time.
Okay. That's, you answered it. So we
Okay.
have some more questions. Jamie says, can there be 2 trustees on the third party trust?
Absolutely. You can name the trust. They can serve together with majority decision, or they have to jointly decide, or they can have independent authority. You can have a panel of advisors for the trustee. So that's in the drafting of the trust. That's why you need a good attorney that understands these. And basically, a third party trust has a way more flexibility because it's not the beneficiary's money initially that goes into it.
We have several more here. Do you have legal resource lists to help set up a special needs trust?
I don't think I have a particular list for that. If they're referring to the code regulations and stuff, that was in the presentation if you wanted to look at the law. But as far as a resource list for me, if I was doing a special needs, I basically need their social security disability letter to show that they're qualified and that they're receiving SSI and not SSDI. I have to make sure that they're on the right type of supplemental security income. It's the SSI benefit. Also, if they're on Medicaid as well, we may have to do that. So basically what I need to see is what assets are in the name of the individual. Can we put some of them in a house or a car to spend them down if they have them and so forth. So if there's some spend down issues, we need to address that up front if they have excess resources. So really, I'm going to do 3 tests. I'm going to do an income test. Are you receiving any income from anyone or anyone else? How many resources do you have? Do you have the possibility of an inheritance? And I need to verify your medical disability letter.
Okay, so Susan, if you need more clarification, just put that in the chat. We have a few more here, except from Kate Berg. If a higher education account had been previously established, is this considered income or can it be moved into a trust? Like a 529, I'm guessing, something like that.
Yeah, the 529. So let me say something about that. We didn't discuss it today. There's something called an ABLE account.
Mm-hmm.
And I think maybe that stands for achieving a better life experience. And if you can qualify an ABLE account with one of those, and you can, I guess, decant them into one of those, I think that's the way to go, because the ABLE account functions like a 529 plan. It's a savings plan that a beneficiary can have up to $100,000 in and still qualify for benefit. So now this is a kind of an odd exception to the SSI requirements. A beneficiary can actually have an ABLE account that they can put resources. Now, the one limit to that is you can only put a maximum right now of 17,000 in it a year from all sources. So one thing about the ABLE account is you can fund it up to $17,000 a year. And then, so if you've got a savings plan with more than that, then you can move at least 17 into it every year until it's all moved over. So I don't answer the question, but that's probably how I would approach that.
And I will send some information out on Able because we are connected with them too.
Yeah.
Gina says, okay, so they inherit a house, the family property, or something in a third-party trust, but you said that the government has to be paid for what they have used in government benefits. How far back does that go? So you would then need a certain amount of cash to pay back the used government money, but once that is paid, the family then gets to keep the house?
Yeah, well, in a first party trust, yes, but I thought the question was a third party. So
Yes.
if someone before they inherit, the will says put it in the trust for my disabled person, that's considered third party. And no, the government doesn't get paid back on those. That's why it's important for family members to do their estate planning. So whatever inheritance is going to go to the child, it goes into a third party trust. Remember the definition of third party, it's not the beneficiary's money. Now, let's say they inherit money outside of a third party trust because they're a member of a family who's inheriting. Now they've got a problem because now the inheritance belongs to them. Now they have to turn that inheritance over into a first party trust or be disqualified. So at least they have the option to set it aside and still stay on benefits. The other side of that equation is they could give it away, but then they're going to be disqualified for up to 3 years. So if they would rather give it away and be off benefits for 3 years, that's another way to do it. But that just all depends. So you need to discuss it at the time and see what's best.
Okay, and Gina has a follow-up question. By the way, Thomas, we are going to be sending slides and the recording of this session. But Gina has a follow-up question. I heard that as of September 2023, they have to show they are paying $350 a month in rent, or that amount will be deducted off their monthly SSI. Can you verify that?
I can't verify that. I don't think that's well.
We can probably find the answer to that through our SSI project.
So the issue there is I could probably answer it like this, maybe, but not necessarily. So if the disabled person is living in the home of somebody else and they are paying for some of their own food, they don't receive a deduction. If they're living with somebody else and somebody else is providing all of their food, then there may be a shelter reduction. It's not technically a food reduction at that point because they changed the law, but there is a situation where if they're living with someone else and someone else is providing all of their food, then in that case, there would be a third reduction. But otherwise, as long as they're providing some of their own food, my understanding is they're still fine.
Kimberly Park says, can an SSI recipient be listed on family land with others as part of their inheritance, or does that affect their SSI as income?
Yeah, that will affect them. So another way to look at it is don't put the individual as an inheritance unless in the same document you have provisions that it should go into trust for them if they're on SSI. Otherwise, it's their money and no one redirected it to a special needs or supplemental needs trust. So a lot of times in forming these trusts, we may form them during the lifetime of the beneficiary. and then we'll name their trust rather than the individual on the deed or something of that effect. But if you just put someone on a deed and there's no requirement that it go in trust, then likely they're going to have a problem and they're going to be disqualified. So I would name a trust in favor of the beneficiary and not the beneficiary themselves.
And this is a follow-up question to Susan's. She had asked about legal resources. She says, do you have a list of lawyers we can refer people to for setting up a special needs trust? I guess around the state, maybe people are in different areas.
I would just have to Google, you can Google special needs trust attorneys and you'll find a number of people that do it. Generally speaking, you don't go to an estate planning attorney, you go to an elder law attorney. Elder law attorneys is kind of a special area in estate planning that deals with government benefits. And so we're a little more knowledgeable about SSI and how that works. And a lot of the elder law attorneys will do special needs trusts.
Okay, and this from John. In very simple terms, if my son is left alone and is on SSI and inherits our house, he can have that without any SSI consequence. However, any monies left can't be used to pay heat, electricity, water, insurance, taxes. Just that alone would be close to $900. But the good news is money can be spent on him for food, recreation, quality of life. Am I generally tracking correctly?
Yes.
There you go.
But let me say something. So in order to get around that deduction, if you pay for those things, what you do is $900 a month. That's about $10,000 a year. You can take money out of that special needs trust, fund an ABLE account. Then the ABLE account can pay for housing and utilities without any deduction to the SSI recipient.
Okay. And again, we'll send some more information on ABLE accounts for those of you who may need that.
Now, there is a limit. Right now, you have to be considered permanently disabled prior to age 26 for an ABLE account to work. That's generally speaking not an issue unless you become disabled later in life. I believe in 2026 or 27, I can't remember the exact date, they're going to raise that to 46 years old. But in the meantime, it's limited to 26 and younger.
And then we have someone else who has a complicated situation and would like to make an appointment with you. So I can put your info in the chat if you're good with that.
Yeah, and I would just tell everybody that anybody on the call, I do free consultations with all my clients on the front end. So there's no fee to come and consult with me.
See if I can find that. Do you want your phone number or email, Dr. Stevens?
Well, oh, and by the way, I'm a doctor of law, but I'm not a PhD. So I would just Mr. Stevens is fine.
Okay.
All right. Let's I prefer that people call the office or they can send an email, and either way is fine. And I can provide that information.
We have one more from Gina. She says, our personal trust says that if we both die, his inheritance will go in their special needs trust, but we have not set it up with a bank yet. What if we die and didn't get it done? Can it be set up after we died as long as our will trust specified it was going to their special needs trust?
Yes, absolutely. And sometimes trustees pass away, and technically what would happen at that time, if the beneficiary has the capacity, they could probably appoint someone at that time to follow through. If they lack capacity, then it might require a third party to go to court and have a trustee appointed.
She says, woo, thanks.
Yes.
John says, this was absolutely great, clear, direct, and extremely helpful. Time very well spent. Thanks for getting out so much info in such a short time.
Oh, yes, I know. I whizzed through it, but everyone's going to get a chance to get the slides, and it's a lot of information, but I've tried to be informative and practical with it, and hopefully hit the high points.
Yes, and if there are no more questions, I'm gonna, well, I'm trying to figure out how to get out of my screen here. I've got, it's fully open. Do you want to just tell me your phone number and I'll put it in the chat?
Yeah, it's 501-400-8250. And also my email is at my law firm is Jurist Law Group. That's how you find me online. Jurist is spelled Jurist. And my email basically is my name, Kimbrough, Kimbro @juristlawgroup.com. And Bonnie has that.
And I just put all of that in the chat, so everybody has that information. And yes, I will share the slides. And when I send that email, I'll make sure, even though I think his contact is in the slides, but I'll make sure his number and email are in the email itself. We have a lot of thank yous. And so we do thank you very much. And perhaps in the future, we can have another session based on people's needs and requests as well. And for those of you who are still on, we are happy to take any requests for additional lunch and learns. We plan to do this at least once a quarter, so let us know if there's something you'd like to hear more about, and we'll try to make that happen. And we will give you back 2 minutes of your hour. Thank you all for being here. And
yeah, it was a pleasure to participate today, and thank you, Bonnie, for asking me.
yes, thank you so much.